Good afternoon, everyone. My name is Madhusudan Sarma, and I welcome you to this next class of N100 series. In this series, we are discussing complete polity from the mains perspective, and today's topic is constitutional bodies. There are a few constitutional bodies that we have already discussed in our earlier classes. For example, Finance Commission, Election Commission, we have already discussed about them. In today's class, we are going to mostly focus on Comptroller and Auditor General (CAG) and various national commissions that are there, and some aspect which are common to all the constitutional bodies. So before moving further, I would give you a very warm wishes of the Deepavali festival. I hope you have enjoyed festival very well, and in some parts of our country, Deepavali is today. So to those people, very happy Diwali. And in case you have any doubt from the previous class, we can take those doubts. You can ask through chat section. Otherwise, we shall start with the very first and basic thing in which all of you can answer it, that which are the constitutional bodies. Can you give me some example of the constitutional bodies? Which are those bodies that we are saying that these are the constitutional bodies? Here is the list. CAG, as I have told you earlier, that Election Commission of India, and Finance Commission. These are also constitutional bodies that we have already discussed. Then we have CAG, we have UPSC, the body that conducts the examination for which we are preparing. This is also a constitutional body. National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes. This is something that has been added through a constitution amendment. Then a special officer for linguistic minorities and attorney general. Attorney general is also a constitutional post. Okay. Out of these, since two we have already studied, we are going to focus on CAG and these three bodies, because I do not expect a question to be asked on UPSC. At best, a question on UPSC, if it has to be asked, it would be asked in prelims examination. Okay, these are also not a substantial body. I mean, on these you can expect Attorney General. We have already had a question. I do not expect it in near future. Uh, this is something that is more likely to be asked in prelims examination. So our focus would be on these four bodies in today's class. Okay, let's see. The first thing is we need to understand what's the difference between constitutional and non-constitutional bodies. So, as the name suggests, constitutional bodies are those bodies which are mentioned in constitution. They are something which are mentioned in constitution. They are not mentioned in constitution, not in constitution. So, how they come into being? They can come into being through some statute or even some executive notification. For example, CBI is not even a statutory body. If it comes through a statute, it will be a statutory body. If it comes to executive notification, we would call it as non-statutory body. It means it has not come through any statute. So CBI, Niti Aayog, earlier there was Planning Commission. These are non-statutory bodies. Whereas we have given the example of constitutional bodies. Constitutional bodies trace their origin to the constitution itself. So what difference does it make? If you are if it is a constitutional body, what difference does it make? See, it has a permanency. If it's a constitutional body, it can only be removed through a constitution amendment. So changes can only be done, changes to its power, changes to its structure, changes to its existence can only be done through constitution amendment, whereas they have less permanency. For example, all of a sudden one fine morning, the new Prime Minister of India in 2014 decided that probably we do not need planning commission. So on very next day, planning commission was gone. A new body, Niti Aayog, came. Maybe with the change of a new government, the new government may decide that probably we do not need Niti Aayog. We need something else. So that something else will come into existence. So there is less permanency. Any change can happen if it's a statutory body. So there has to be a change in a statute. Or if it is non-statutory body, only through executive resolution. Even parliament's law is not required. So executive resolution can be passed by a simple cabinet meeting. That's the major difference. Other thing is, like in case of constitutional bodies, the constitutional body submits their report to president. Then president lay it to the parliament. Okay. Whereas non-constitutional bodies, they submit their report to the government. See, practically, there is no such difference between the two. Because whether you submit your report to the president, ultimately the president means it will go to the concerned ministry only. But yes, in what you say, ceremonial sense, it has a difference. It has higher standard if the report is directly being submitted to the president. It is relatively less impactful, less weightage is being given only ceremoniously. Practically, like in both the cases, the report is going to the government only. Okay. Then in case of say constitutional body, appointment by president appointment is done by president, whereas in this case the appointment by government. Again, it is also a ceremonial difference only, because practically it's not the president who is appointing, practically it is only the government who is appointing. But yes, ceremoniously it is like the president has to appoint by a warrant under his hand and seal, whereas in this case it is appointed by the government only. Okay. So as such, in terms of a status, there is a difference. Practically, probably there might not be much of a difference, but it gains the status of constitutional body is higher as compared to their non-constitutional counterpart, that you have got a constitutional status. There was a question that what will change if a constitutional status is given to a particular body. Your argument is going to be on the basis of this. So these are the things that are going to change if we provide constitutional status. Okay. Then there has also been a question that how do you provide constitutional status to a body? UPSC has asked this question, and the answer is very simple. As such, this does not even belong to this chapter. Rather, so the constitutionalization process is very simple. You have to bring about a constitution amendment. Constitution amendment under Article 368. And these bodies, to give a constitutional status to anybody, this does not impact the federal structure. So that's why you need not get it ratified by half of the states. Only simply passing a resolution by both the houses through a special majority is sufficient. So first, it can be introduced in any house. So first thing first, it can be introduced in any house of parliament. Any house means either Lok Sabha or Rajya Sabha. It can be introduced in either house. Well, and there is no requirement of president prior approval. Okay, it is not necessary that you have to get the president's approval. No. So once a bill is introduced in one house, it would be passed by a special majority in that house. A special majority means 2/3 of the member present and voting plus half of the total strength. So, we have discussed it so many times. We have already studied the Constitution Amendment chapter. There we have seen that with the special majority, one has to pass the bill. Then it will be referred to the second house. In the second house again, it has to be passed with the special majority. If it was introduced in Lok Sabha, it will go to Rajya Sabha, then it will go to Lok Sabha. Then it will go to the president for his assent, and the Article 368 says that president must give assent. The president does not have any veto power in case of constitution amendment bill. After president assent, then the body become a constitutional body. That's the process we have already discussed. It is simply the process of constitution amendment. We have already seen it in when we were studying the constitutional amendment chapter. Okay, I don't think there could be any such issue, but yes, if the question comes, you should also give the example that through 102nd Constitution Amendment Act, National Commission for Backward Classes was given constitutional status. So, you must give this example as well, that this is something that has been done in the past as well. Okay. In case more space is there, you can say that in case there is a difference between the two houses, there is no provision for joint sitting. It has to be passed by a special majority in both the houses sitting separately. There is no provision for joint sitting. Okay. Next, now we shall start with one of the constitutional bodies, that is CAG, Comptroller and Auditor General. So, see, CAG has been in the news time and again. Like earlier, it used to be in news more often. In recent time, like when Vinod Gupta was the CAG, at that point of time, it was very much used to be in news. Recent days, it is less in news. But still, it's a very important institution, and this year also there was a question on CAG. So let's see what are the duties of CAG. First of all, you should have an idea about the range around which the articles are there. Like exact article number about CAG is 148 and its duties are mentioned in 149. However, even if you do not remember the exact article, even if you remember that it is around article number 150, when the institution of CAG is mentioned in our constitution, that is also sufficient. Now, see, what's the full form of CAG is Comptroller and Auditor General. See, we understand the CAG does auditing, and there is also Indian Audit and Account Service. Usually, this is the preferred choice of people who do not get IS, IPS or IRS. Then, and also IFS. Then this is the service that they usually opt for, Indian Audit and Account Service. It works under CAG. Now, the question is that Auditor General, we understand what is the meaning of this Controller General. And again, this is not controller, this is comptroller. So, comptroller means the head of the account department. Okay, if you look at the dictionary meaning of the word comptroller, it means head of the account department. But if you look at the Lakshmikant also explains that comptroller means the one that controls the purse, like the one who will allow if an expenditure should happen. I mean, whenever the money is withdrawn, the one who controls that purse is also known as controller. So there are two possible meanings. One is head of the head of account department, and the another meaning is the one who controls the purse. But Indian constitution makers probably did not have this meaning in their mind, because Indian CAG does not control the purse. When any money is being withdrawn from Consolidated Fund of India or Contingency Fund of India, CAG has no control at all. It is so effectively it acts as the head of the account, and this is more so clear because originally CAG used to do two kind of function: accounting function and auditing function. Even today, for a state governments, it is doing both the functions, the accounting function and auditing function. So for a state government, it is compiling the accounts of the state government. It recommends the president over the forms of account of both union and state government. This is something which is written in Article 150. Initially, it used to compile the accounts for union government also, but then there was this office of CGA, Comptroller General of Accounts, was created, and this office, Comptroller General of Accounts, like if you suppose you join, there is a Indian Civil Account Service also. So in case you join Indian Civil Account Service, in that case you work under Comptroller General of Accounts. So this office compiles the account of union government, whereas the CAG compiles the account of a state government. Now the next question that must come to your mind, that why we separated, like originally in 1950, since 1950, the CAG was doing both these functions, the compiling of the account as well as auditing function. So why was it separated? The answer is pretty much simple. See, auditing is like someone who is doing inspections, someone who is looking at if things are not going right, if something wrong has happened. If the CAG is maintaining the account and it is also auditing the account, there is a conflict of interest. I am myself also preparing the account, and I am myself also looking if I have done anything wrong. It must be done by someone else. Then only he can look at the account with an independent mindset. He can have a third eye view, an open view. Okay, so because of this reason, it was decided that probably this accounting function should be given to some other institutions, and an institution of CGA was established in 1975. So after 1975, for union government, CAG is only doing the auditing function. Here one more thing is clear, we do not have we have a common CAG for union government as well as a state government. Again, this is another example that you can write for centralizing tendency in Indian constitution. Like for a state government and all the state government and union government, we have a common CAG. Okay. Next is, let's see what are all the institutions or what all different kind of accounts that are audited by CAG. So first is it expenditure from the Consolidated Fund of India. All the expenditure are audited. Receipt to Consolidated Fund of India. All transaction of contingency and public accounts. So there are three funds. CAG effectively audits all these three funds of the Government of India. Then government companies and corporations, so whatever be the revenue expenditure of the government company, it does not come to Consolidated Fund of India. The companies have their own accounts, the money goes to their account. So these are also audited by CAG. So even private companies accounts are audited. It's not that government companies are audited, private companies are not. But private companies keep their own auditor for auditing function. Whereas for public companies, PSUs, CAG is their authorized auditor. They cannot have their other auditors. Okay. Then all the bodies and authorities which are substantially financed by the government. So any body or authority, even if it could be a private body, it could be a non-government organization, if it is substantially financed by the government, it can be audited by CAG, and then any other body or authority on request of president. So in fact, Supreme Court has also said that the utility companies or like the telecom companies, since telecom companies are using a spectrum and a spectrum is being shared with the government, like there is a revenue sharing mechanism. So because of this reason, they are substantially financed by the government, and Supreme Court has said that CAG audit can be done. And all the body and authority on request of president and governor. Here you can see that local bodies, whether it is rural bodies or urban bodies, they are not audited by the CAG. So in case governor makes a request, then only local self governments are audited. So they are not regularly audited. Occasionally, governors makes a request that now maybe after a gap of 4 year or 5 year, or maybe particular schemes to be implemented by the local bodies, they are audited. Okay. Any doubt till now? You may ask. Is there any other functions that we have seen that this is also done by CAG in any of the earlier classes that I might have told you? CAG certifies the net proceed of taxes. Where have we seen this net proceed? Taxes collected by central government. So we have seen that there are few taxes which are which are collected by the central government, but it is distributed or rather shared with a state government. Now there the total tax collection is not shared, rather the net proceed of taxes are shared. What is this net proceed of taxes? Net proceed of taxes meaning that obviously central government incurs certain expenditure also to collect the taxes. They have the revenue service officers, etc. So this cost has to be subtracted from the total money collected in the form of tax. Maybe that government collected 5 lakh crore rupees, and then out of which 1 lakh crore rupees was spent during this collection as well. So CAG will certify that whether you have spent 1 lakh crore rupees or 75,000 crore rupees or maybe only 1 crore rupees. Whatever is, this certification is given by CAG, and then the subtracted money, if it is 1 lakh crore, 4 lakh crore would be, I mean out of 4 lakh crore there would be sharing with the state government, and then it would be based on the formula suggested by Finance Commission. Okay. Now let's move to the next topic with respect to CAG, that is what are the different types of audit that is done by CAG. So CAG does two different types of audit. One is legal or regulatory audit, another is proprietary or performance audit. This is very important thing. You must pay attention. Legal or regulatory authority is auditing is mandatory on CAG, whereas proprietary audit or performance audit is optional. Okay, so this is like GS paper and this is optional paper. So like in the GS paper, what you do? You just do the superficial, I mean, do not do the in-depth study. I'm not saying superficial, but you do not go into the detail. So that's the same kind of, like, this is the audit. If it is being done, it would be merely testing whether you are complying with the laws or not. Whereas this is going to test a in-depth understanding. So this is what I say, that there is in legal audit or regulatory audit, CAG test for 3P. What are those 3Ps? First is whether uh, when a money has been spent, if a money has been spent with the, or even if it a tax has been collected, both in both the cases, like there could be some revenue coming to the consolidated fund of India, there could be some money to be spent from consolidated fund of India. So in both the cases, first P is says that whether it is being done by the person authorized, the person who was doing the spending, whether he was the one who was authorized by the parliament, because see, any collection or any expenditure happens only after parliament authorizes for it. So parliament has authorized to a particular person, I mean it could be the minister, it could be the bureaucrat or whoever it is. So whether that person authorized has done the expenditure, first thing. The second thing is whether it was done for the purpose authorized. And the third thing is whether it was under the permissible limit. For example, for MG Narega, if the Ministry of Rural Development was sanctioned 50,000 crore rupees. So CAG will first see that if only Ministry of Rural Development has spent this 50,000 crore rupees, it cannot happen that Ministry of Defence has spent the money of MG Narega. This is not allowed. Okay. Second thing is that the money, even if Ministry of Rural Development cannot spend the MG Narega fund for any of his other schemes like Prime Minister Gram Sadak Yojana, even if the same ministry is implementing both their schemes. So second would be that purpose, the same purpose it should be spent. The third thing is that if 50,000 rupees was to be spent, only that much money should have been spent. You cannot even spend 1 rupee more than the limit that was sanctioned by parliament. So these are the 3P test which is done by CAG under legal or regulatory audit, and for all those items that I just showed you in the last slide, it is mandatory that CAG conducts this audit. Okay. In proprietary audit, CAG goes one step further. It does, apart from 3P, 3P would definitely be tested, but it also tests something called as 3E. What is? It looks at economy, efficiency, and expenditure. Sorry, economy, efficiency, and effectiveness. What are these three terms? Economy, efficiency, and effectiveness. Very subtle variation is there between these three. Otherwise, like to a common man, all these three seems the same. So, economy says that whether you have completed a particular work in the least amount of money. For example, if you are making a road, whether you have made this road in the least amount of money, economical, whether this was the most economical option, like you could have made a road using tar, you could have made a road using some kind of engineering textile, you could have used the brick of a kiln, or you could have used the brick from the fly ash. So whatever been the options that were available, whether you chose the most economical option or not. The second is efficiency, whether the output per unit input was most efficient or not. And per unit output efficiency is simply output divided by input. Whether this was high or not. This is something which is to be tested under efficiency. Okay, so suppose you have spent 100 crore rupees, you have made 5 kilometer of road. So per kilometer of road you have spent 20 crore rupees. Well, if some other state or some other areas the average per kilometer cost is say 5 crore rupees, then you did not had enough efficiency. Okay. Uh, third E is effectiveness. Effectiveness is about outcome. What was the purpose? What was the goal to be achieved? For example, when you are implementing MG Narega, your goal is to provide employment. Your goal is not to spend money. Okay, when you are spending money on education, the outcome is to increase the literacy rate, to increase the number of graduates, to increase the number of students, like enrollment of the students, the literacy outcome of the students. Whether that has happened or not, that is effectiveness. You can build a road, but no one is traveling using that road. Maybe the road was not required in the area, or maybe the road is not of good quality. So if it is not leading to more people traveling through that area, more economic activity happening in that area, if it is not leading to more of a employment generation, if it is not leading to more of a poverty reduction, then the effectiveness of the road is very less. Well, obviously, these three things, economy, efficiency and effectiveness, is also subjective in nature. They involve an element of judgment. They involve an element of subjectivity. Whereas the legal and regulatory audit is very objective in nature. What was prescribed by law, the CAG will simply match with that prescription, whether the implementing agency has abided by that law or not. So that's the reason why it is kept optional. Apart from this subjectivity and judgment, it is also more time consuming, and obviously it is more technical in nature. It requires more expertise. So that's the reason why it has been left optional, that only the matters which are very important in national interest, only when CAG will have enough resources and time at its disposal, it will conduct proprietary audit. Okay, and the example of proprietary audit is when CAG talked about the 2G spectrum allocation. So see, we normally see that in 2G spectrum allocation, there was a scam of 1,76,000 crore. But as a CAG did not say this. If you read it more closely, CAG had said that, see, there are various other mechanisms. Probably we could have gone through the auction route. Okay, so what CAG is saying, that probably there is other way which is more efficient if we go through auction route, and in that case we would have earned more money. Now, so this is a kind of a speculation. We would have, had we gone through, and then CAG says that, see, probably we could have got this much of money, and CAG had given three different numbers. It used three different methodologies. Based on this methodology we would be able, and it gave three different numbers. Out of these three numbers, the maximum number was the one with 1,76,000 crore, which was picked by the people or media, etc., and that was publicized. Okay, so it was not that someone took away that 1,76,000 crore rupees from the government money. This is a notional loss. So that's why I'm saying that there is subjectivity. There is an element of judgment in this. That probably there was another way out. That way was more effective, more efficient. And had we gone through that route, we would have got this much of more money. Okay, and then those speculation, projections, etc. is definitely technical in nature, because actually it has not happened. Actually, we did not go through auction route. So, like, how does auctioning work? How do we get the money? What should be our premises? What should be our assumptions? These are all a very technical matter. It requires expertise. So, this is an example that you can give for proprietary audit. Okay. So, in this case, in doing the proprietary audit, CAG also questions the wisdom of decision making, whether the most wise decision was taken. Okay. Whereas in legal and regulatory audit, no such wisdom questioning happens. Okay. Next topic that we study is whether the audit of CAG is effective or not. Well, definitely, I mean, whenever such question is asked, we always give answers in two dimensions. Yes, there has been effectiveness. We will give certain examples how it has been effective. It's like the same thing we have done for election commission in context of MCC. But at the same time, then we shall also write that there has been some challenges, there has been some problems, there has been some loopholes. Okay, so let's see. First is that definitely it has brought to the light some misappropriation of funds. See, here example is not going to be 2G spectrum scam, because in that case misappropriation has actually not happened. Misappropriation, it has found various cases, like we have discussed, that the local self government bodies, they have not submitted utility certificate. Since they are not submitting utility certificate, probably they might not have utilized the money, or they might have misappropriated the money. This is something that came to the light after CAG audit. Next is, it has unearthed various scams, like we have just discussed 2G scam, even Colgate scam, that has also come to the light after the 2G, after the CAG audit only. Then it has also brought about policy changes, like its purpose of the CAG audit is, proprietary audit is to test the wisdom, and then it suggested certain wisdom that probably we should have gone through that route. And in that case, for example, after this, the natural resources allocation is happening through auction route only. Before that, like during 2G spectrum allocation, had happened through first come first serve basis. Next is, it also exposed inefficiency. For example, like in Delhi Commonwealth Games, CWG, they were buying tissue papers which were costing thousands rupees a piece. So this was definitely an inefficient purchase of goods by the sports implementing agency. Next is, it also spreads awareness, because when CAG reports are tabled in the parliament, it is widely discussed and debated. So this way it also spreads public awareness. So this is how CAG audit has been effective. However, there has been certain lacuna, or you can say challenges, in CAG audit as well. What has been there? The first thing is, it's a post facto exercise. What is meant by post facto? Or other, in few places you can say it is a post mortem exercise. So it's like, when is post mortem done? When a person has already died. Now that a person is already dead, you cannot make him alive. You can tell about all the things that probably he has died because of choking, because there was a respiratory illness, because there was lack of oxygen, whatever you may decide. Probably someone shot him, probably someone stabbed him, but you cannot bring him back. The person is dead. Same is the case with CAG exercise. You can talk about all the notional loss and all those things, but the money that is lost is lost. Money has already been misappropriated. The money is gone. So that's the biggest limitation of CAG audit. Next is that there are two things. Even one thing is that something wrong is happening. For example, in case of Colgate scam, the coal allocation has happened between 2004 and 2009, whereas the CAG audit report only came in 2012. So some scam or something wrong started happening in 2004, which was brought to the public notice in 2012 only. That is the gap. And even after CAG report bring about some uh, misappropriation or any such thing, it is taken up by the public account committee a little late. Sometimes report remains pending with PSC for years, and PSC does not give a look to it. Okay, and there has also been in recent time. Okay, next is PSC does not even go through all the reports or all the complete report. Only around 15 to 20 paragraphs are studied by or examined by PSCs. So that's another problem. First is that they are doing it a post facto exercise. Even then they are submitting report with the delay. Then PSC is taking it with further delay, and then only PSC is taking only 15 to 20 paras. Not complete report is being examined either. And even after these many delays and all those things, most of the times no substantive action is taken. And in recent time, there is another problem that has occurred is that CAG is now giving less number of reports. Like between 2019 to 23, between 2019 and 23, on an average every year CAG is producing 22 reports a year. Whereas between 2014 and 19, it has given on an average 40 reports a year. So now CAG is also examining less number of items every year. People are accusing, people are saying that probably CAG has altogether stopped conducting proprietary audit. It is only involved in the bare minimum requirement, that is legal audit. Okay. Then there are other accusations with the audit principle itself. This is something that the way CAG is acting, but there are people who are not happy with this overall mechanism of auditing per se. They simply say that auditing is a purely bookish exercise. You do not go on ground and see what is the ground reality. Now there are two different kind of acquisitions here. First thing is that maybe if on paper you have done everything right, CAG will never be able to catch if anything is wrong with you, anything misappropriation has happened. If like those uh, local self-government, if they had produced the utility certificate, CAG would have never come to know that there has been any misappropriation, even if something forced, something like that is done. Second thing is that those who are executive agencies, they say that these auditors, they do not understand the ground problems of ground reality. For example, I will just give you very briefly give you an example of MG Narega. So practically in my state Bihar, the daily wages are somewhere around rupees 500 or 600. Okay, but MG Narega prescribes something around 250 rupees per day. So effectively, if any project under MG Narega has to be implemented, you can only pay rupees 250. But in rupees 250, you cannot hire any wager, because in the local market the wages are rupees 500. So practically what is done is, wherever like the requirement is of 5 people, 10 people are shown on the books. The Aadhaar ID, the bank account detail, everything of 10 people or even 12 people are collected. Then the payment is done to them at the rate prescribed under MG Narega rules at rupees 250 only. Whereas only 5 people were working, and the rest of the 5 people were working in the accounts of 12 people, the money has been transferred. These rest of the 7 people, they will transfer their money after it is deposited in their bank account to the person who were actually working. Obviously they will take a cut. So maybe they have got 250 rupees in their account, they will keep 50 rupees, and 200 rupees they will transfer to the person. So effectively it has, I mean, this is also a kind of misappropriation, because if you are giving money to a person who is actually not working, this is called misappropriation. But practically, as per the rules, it was never possible to implement any project because the wages are so low. So if you listen to this story, probably both the sides, the one side which is accusing that you are doing corruption is also right, and the side which is saying that practically without doing corruption, I cannot implement anything. And there is a problem with corruption, that there is always a slippery slope. If you can show in place of 5, 10 people or 12 people, because well, you have to give wages, you can always say so 20 people, so that I mean, you are also able to keep some money if you are the person who is in charge of all these programs. So this is how the corruption sips into the system, I would say, through the backdoor channel. And now those people who are executing the project, they say that CAG is not understanding the ground reality. Next point is that it is a fault finding rather than constructive feedback. So auditing is expected to be, auditors are supposed to be a friend, philosopher and guide, not only to PSC but also to the executing agencies. The agency which are executing the program, they should get feedback from the auditing function, that these are the things that they can improve, like economy, efficiency, effectiveness. How can they bring about this economy, efficiency and effectiveness? This should be this is the ideal way of auditing, but mostly auditing has been reduced to a fault finding exercise. Auditors are not liked by the executive agency. They should be acting as an advisor, rather the auditing has become a policing function rather than an advisory functions. Advisory role has almost completely gone. Next is that CAG does not have the power, like I have told you, it does not control the purse, no control on purse. Not only that, it doesn't have control on purse, it can't, even if it says that there has been misappropriation, there is corruption, it can't penalize anyone. The only thing it has to do is, it has to do the auditing and then report it to PSC. The parliament will do whatever it wants to do. A parliament, why would government take any action against itself? See what is happening. CAG has found out that something wrong has happened. It will tell the same government under whose eye that wrong has happened. Why would the same government take action against itself? Very little chance. Okay. Then there is also problem with independence of CAG. Recent time it is being said that the government is appointing its favorites as CAG. Again here the same problem that is there with election commission. The CAG is appointed by the president directly. President means the government. So the one person who is to be audited by, like the government who is going to be audited by the CAG, the same government. So I am appointing my own investigating officer. In that case, I will definitely not want to be investigated properly if I have done anything wrong. I would appoint a investigator who is very much pliant to me, who will listen to me, who will probably not say anything wrong against me. Okay. For example, the current CAG is being considered as a loyalist. He is from the Gujarat cadre. He is a loyalist of both Amit Shah and uh, the current Prime Minister, Home Minister and Prime Minister. So these are the accusation made. Very carefully you have to write that since government is appointing the CAG, there is accusation that the favorites are being appointed. Another point also you can see, like this is something that has gone to Supreme Court also. This is in principle very correct, but as such again, legally there is nothing wrong in it. See, retired IS people are appointed as CAG. Like before this person was also the current CAG was an IS officer. He was in Ministry of Finance. Before that, the person was in secretary in Ministry of Home. The before that, the person was secretary in Defense Ministry. So definitely, since it's a post facto exercise, they are going to audit the things that had happened under their watch. Like this matter also went to the Supreme Court when like Defense Secretary was appointed as the CAG, that he is going to audit the accounts when he was the Defense Secretary, and that was the time when Rafale deal was very much in uh, conjunction. So this is what has happened. Rafale deal has been finalized under the person, and the same person is now going to audit that deal. Why would he find any fault in that, even if something wrong has happened? So that's why, like even economy, efficiency, effectiveness, the subjective things, the suggestion, etc., he will not try to give any such thing. So that's the problem with lack of independence that is there with CAG. If you have any doubt, you may ask here with respect to any of the challenges that I have discussed. If you do not have any doubt, please like the video and share with your friends so that they can also take benefit of this series of lectures. These are very important. This is something a lot many questions have been asked. I can guarantee that next year also around 2 and 3 questions, sorry 2 and 3 I am saying, out of the 10 questions, around 8 questions or 9 questions are going to be asked from these topics. Okay, let's move to the next topic, suggestions. What are the reforms that can be taken? Uh, See, the challenges that we have discussed, in that background you can always say one thing is whatever the suggestion that we have given for election commission, the similar suggestion you can give for CAG also, like there should be a committee. So first is bring about independence to the office of CAG. And as such, unlike election commission, the problem in CAG's office is very much limited. Like already the expenditure of the CAG office is charged on the Consolidated Fund of India. Removal is done through a very rigorous process that is same as the process for removal of Supreme Court judges. The only problem lies in the appointment of CAG. Okay. So if we address this appointment process, things are going to improve on the independence front. Then the other thing suggestion we can give is that expansion of ambit of CAG. Currently there are certain items like with the LPG reforms. Now more and more number of projects are being implemented through PPP mode. Okay. And like there are various NGOs etc., which are also getting funding from the government. So these are the things that should also now come under the ambit of CAG's audit. Okay. Next is we should have a collegium system of appointment, is like to make sure that there is independence. And like CAG should be made a part of public account committee. This is something, a suggestion given by, given in this is something that happens in UK and Australia. And in UK, CAG also act as controller of account. So it's not merely a post-mortem exercise. Even before the money is spent, CAG has a look at whether the money is being spent as per the authorization of the parliament or not. Okay. Then there is also a recommendation that CAG's term should be increased, as in the case of UK and USA, where the term is 10 and 15 years. In India, the CAG's term is very limited. A retired IAS person is appointed, 65 years is the age of retirement. So usually he remains in office for 3 or 4 years only. And when you are doing an auditing of any scheme which is going through say 4 or 5 years, like a long term propriety audit, if you have to do, probably CAG is not adept enough to do those things. Next is, there should be, as per the law, there should not be any delay in the supply of data, records, etc. There has been various cases where CAG keeps on asking about the document, it doesn't goes, then CAG has to utilize its power, it has to threaten, and then the data, etc. are provided. There is also an recommendation that CAG should be made a multi-member body. Why is this recommendation? See, we have seen that there is a need for doing more and more of propriety audit. Propriety audit is a kind of quasi-judicial function. Okay, quasi-judicial function. Quasi-judicial function, why I am saying, because here you are passing a judgment and there is an interpretation, like when the CAG gave a judgment that probably you could have gone through auction route and you could have earned more money. It was interpreted as a scam, right? So there is a wider ramification of all the reports of the CAG. And in any quasi-judicial function, it is recommended that there should be at least 2 minds that should be applied. Like we have seen in the election commission, now we have a 3-member body. So similarly, a recommendation is being given that probably we should have multi-member CAG as well. Okay. So if a question comes that whether we should go for it, you should take a stand in favor of it. That yes, probably we can go for the multi-member CAG. There is nothing wrong in that. But not like election commission. All the CAGs should be given equal security of tenure, equal protection from removal and like government interference. They should be protected. Okay. And then there is also a suggestion that like proprietary audit should also be made mandatory. Strengthen the workforce of CAG and make the proprietary audit mandatory. This is another suggestion that you can give. And like we have seen that CAG does not have the power to punish, you can give a suggestion that CAG should have the power to impose penalties, etc. Power to impose penalty, and this is something which is there in the with the CAG of France. So why we are saying that there should be a power to impose penalty, we are giving reference to France. When we are saying that it should also act as a controller of account, we are giving reference to UK. When we are saying that it should be made a part of PSC, we are giving reference to UK. So these are the good best practices which are there in the world over that we should adopt in Indian conditions also. Okay. Any doubt till now? This is all that we have to cover about CAG. If you have any doubt, you may ask. If you are watching it in recorded mode later on, then also you can ask doubt by putting your comments. Next is National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes. These are the three national commissions which have got the constitutional status. And for these three national commissions, we have the very common, very similar provision in our constitution. If you actually go and read the article 338, 338A, 338B, probably you will find that they are so similar, copy pasted kind of thing. Okay, they have not even used artificial intelligence. They have simply copy pasted it. So we shall see, but yes, there are certain items which are different also. And see, there are three kind of questions that can be asked. One is, what are their role? You got to remember the constitutional provisions. What is the mandate? What is the expectation from them? Second is whether they are effective, whether they are not effective. Okay, and then suggestions. This is all that has to be studied. There are common problems since they have been given the common powers. There are common problems also. So we will study them together. There is no need for studying them separately, but obviously you will replace scheduled caste, scheduled tribe or backward classes as per the demand of the question. This is the adjustment that is expected from you. Okay, let's see what are those common provisions. So common provision is simply they have been they are mandated to inquire into the complaints. So people will file complaint, they will have to inquire into those complaints. Then they have to investigate and monitor the safeguards. So already for the protection of say scheduled caste, scheduled tribe, there are already safeguards like Civil Rights Act is there, SC/ST, Prevention of Atrocities Act is there. So they have to investigate and monitor whether these safeguards are working. After investigation, what will they do? What will they do? They will give a report to the president. So report to the president on working of these safeguard. What next they will do? They will also recommend for some effective implementation of this safeguard. In the report, they will do some recommendation. Okay, and then there is another role that has been given to them is advising on socio-economic development. So they have the dual role. One is of protection, another is of development. For protection, there are two ways that they are doing. One is like individual can apply through complaints and another is proactive protection, that is through the safeguards, etc. This is mostly through legislative measures, rules making, etc. that they will recommend, and this is something through individual complaints mechanism. Okay. And the last thing that is there with everything is that they have to discharge such other function as specified by president. So president can ask him to look into some other matter as well, look into the schemes, look into the some specific law, etc. Give suggestion about certain items. So any other item that has been referred to them by president, they have to look into that. This is something common for all these three commissions. Okay. Any doubt? And say whatever report that they submit, again president will lay this report to the parliament, on the floor of the parliament with an action taken report. Okay, the president will also say that what are the actions that have been taken. It will also explain why if certain recommendation is not accepted. Okay, so a memorandum would be put forward which will explain the action taken, not taken, and reasons for non-acceptance of any of the recommendations. Okay. Other provisions which are factual in nature, mostly used for the prelims, is like their condition of service. Condition of service is to be decided by president, not by a law of parliament. In case of say election commission, this is to be decided by a law. So that's why a election commission act was there. Now in their case, the condition of service is decided by president. Okay, they are all appointed by president. All the members of these commissions, they are appointed by president. And there is one more provision which is there, that the union and state government, this is very important provision, that union and a state government shall consult the commission for all important policy matters relating to these communities. So, in case an important matter related to National Commission for Scheduled Caste is there, say suppose government is bringing a new law, government is bringing a new scheme, government is doing any such thing which is important policy matters, the union government, if it is considering, or a state government, will definitely consult these commissions. Here, shall consult is the word that is used, with one exception. The article 338b mentions, like 338 mentions for National Commission for Scheduled Caste, 338a mentions for scheduled tribe, for B mentions for scheduled backward classes. So 338b mentions that all important policy matters, they would be consulted, except if a state government has to accept, a state government including or excluding, or rather you can say that amending its OBC list. From that purview, see, one more thing is there. We do not have provision or the constitutional bodies for say a state commission, like we have a state public service commission, and that is also a constitutional bodies. There is constitutional provision for them. But similarly, we do not have a state commission for backward classes, a state commission for scheduled caste, or state commission for scheduled tribe. Okay, so same national commission would be consulted by a state government also in case there is a matter, policy matters that they want to take. But one exception has been given, that if states are amending their OBC list, in that case they need not consult the national commission. So simply like they do not want that the national government should have any interference in a state government policy matters. I mean, a state should be given autonomy to include or exclude any caste from their respective OBC list. Okay, we shall come back to this provision again. In today's class, we are also going to study what is the role of NCBC in OBC list. This is something which have been in debate last year a lot. So this is also something that we shall discuss. I will come back to this provision again. Next is, there are certain common challenges or criticism that is valid for all these three commissions. First is that they are all appointment by president. So as such, a president means government, and government is appointing its favorites. See, they are the commission which have to give a report on the safeguards, on the legislations, or they have to address the complaints, etc. See, against whom are going to be these complaints? Invariably, it is the government. See, the government is not looking into complaints. That why someone has to go to this commission, national commissions. Now, the government appointed commission is expected to give a report against the government action itself. very least likely that it is going to happen in an unbiased manner. So that is a common problem with them, that ineffectively they are a toothless body. All them, they are a toothless body. They simply toe the government line. Even in their report, investigation report, they simply justify the stand taken by the government. Okay. Then they are merely an advisory body and their advice is not binding. Okay, they have no power to punish or award compensation. Like, at least they should have power to award compensation. Like, if they find that something wrong, injustice has happened with someone, they should have the power to award compensation. That is also not there. And it has often found that in high profile cases, these bodies, they do not act decisively. Okay, they simply confirm the government action, confirms the government stance. Whatever is the stance of the government, stand of the government, the same stand is taken. And there is also delay in conducting inquiry. There is all very often that things are first taken by the media. It is already, media trial has already concluded. Then these commissions wake up from their slumber and then they go. By that time, everyone knows everything. There is no need of any inquiry by these commissions. And then there is also report is submitted with a lot of time lag. For example, in case of National Commission for Scheduled Tribe, they have submitted the report for 15-16 only. For any financial year after 2015-16, their report is yet not tabled in the parliament. In fact, they do not have regular meeting. The same NCST, it has no meeting in 2020-24. Only 2 meetings in 2023. If you are not regularly conducting the meeting, if you are not proactively active when there is a need, what's the utility of these commissions? So that's why a lot many people are saying that probably they are simply draining the government money or the taxpayers' money. They are not doing any useful function. Okay. So we have to simply write both sides. We do not have to take any side. Obviously, there is a bit of truth in both. They are doing some utility function as well. They are not being as effective as we expect them to be. Okay. Next is, whenever you are talking about their effectiveness or lack of effectiveness, all those challenges, etc., the common problem we will definitely tell. But see, if like their role is protection as well as development. So if we give any data of lack of development of these communities, this also proves our point that probably these commissions are failing. These commissions have not been so effective. So I would give you a data, and this data is also useful in governance paper. This data is also useful in society paper. Okay. So the same data SCST, and in your optional also, if it is SCST are involved in your optional, there also you can use this data. Okay. See, the share of scheduled tribe in their population is 8.6%. For scheduled caste, their share is 16.6% in population. Okay, so this gives you an idea of their relative strength in India's population. Then, literacy rate among scheduled tribe is only 59%. For women, literacy is still less than 50%. Whereas for scheduled caste it is 66%, national average is 74. So you can see that both scheduled tribe and scheduled caste, their average is less than the national average. The infant mortality rate is more than the national infant mortality rate. It is 44 for scheduled tribe and 39 for scheduled caste. The poverty, this is something which is like the biggest problem. The national average has come down seemingly a lot to only 15%, whereas in case of scheduled tribe, half of the population is still below poverty line, and this is the latest NFHS 5 data. So, I mean, probably you can think 8.6% is total population. So, 4.2% of Indian poor are coming from here. One third is coming from here. So, around say what you can say 16.6. So, 5.5% approximately coming from here. So, out of the 15%, approximately 9.7%, like 10% poor are from scheduled caste and scheduled tribe category only. So, two-thirds of India's poor are belonging to these categories. This is disproportionately because their population share is merely 24%, 25%, whereas their share in poverty, poor people, is disproportionately more. This shows that probably they are falling behind the mainstream. And then you can say that their representation in government job, despite getting reservation, their representation in group A is less than their population share. Probably after say so many years of reservation, it has come on par with approximately the reservation that is given to them. Okay, but you can see, especially in case of scheduled caste people, you can see that their share in government job keeps on increasing towards group C and group D level. In group D, they are disproportionately represented high, whereas in group A, their representation is less. So, probably they are not getting the good quality jobs, they are still highly represented in relatively less skilled job. Okay. And this commission is also accused, the National Commission of ST and SC, that probably their attention is less to the less attention to poor SC ST. Their attention is also, like the commission's attention is more towards the influential section, the problems of influential people among SC ST. This is an accusation which is made. Okay, and obvious true also. If something wrong happens in Delhi, the commission people would most likely be there in Delhi. It is easy for them to go there and look at it. It would be covered by the media also. Something happening in the farther corner, say maybe in the with the tribal people in the village of Jharkhand, it will not get the media attention, and CST will also not bother much about it. So this is how unfortunate practical reality is there. Okay. Next we shall see about the NCBC. So these are the specific data. Apart from those common points, some specific point by SC and ST that you can write, that I have given in the last slide. Some similarly, some specific point I will give you with respect to the limitation of National Commission for Backward Classes. Like there has been constitution amendment, but that constitution amendment is silent on periodic revision of OBC list, and this is something which was asked to the government by Indira Sawhney case. As per the Indira Sawhney judgment only, the government has the Supreme Court had instructed the government to make a National Commission for Backward Classes. Now the government gave it a constitutional status. But in that judgment, one more thing was said, that there should be a periodic revision of OBC list, and that thing has not been implemented. Once a caste is included in the OBC list, it is included forever. Once a backward, always backward. That's obviously practically not true. Next is that we do not have caste census data based on which the National Commission of Backward Classes could give any recommendation. Lack of data. is leading to faulty policy making. You are making policy based on old data. Definitely, it can have deviations from the ground reality. And whatever is the structure that we are following the same structure which was there when it was not a constitutional body. So now if a question is asked whether it would be effective or not, probably the question, if it was not effective earlier, it will not be effective now also, because you are having the same structure. In fact, it is also accused that a structure does not give a sense of it being a expert body. Doesn't look like a expert body, like an expert body. There is no such requirement of like those who have expertise in sociology or those who have expertise in developmental activity. They should be a member. These criteria have been dropped. And OBCs are still underrepresented. Their representation in government job is around 21%. Definitely, like the reservation has been given to up to the level of 25%. And like Mandal Commission has estimated probably the share of backward classes in India's population around 50%, but their share as of now is around 21%. Okay, and this is like composition doesn't reflect an expert body. I have already told you. So these are the specific point that you will write about the National Commission for Backward Classes. Any doubt you may ask? Okay, let's look at the suggestions. Now there are broadly two different type of suggestions that you can give. One is that there is a need for independence. These organizations are as such now a government representative only. These are extended arm of the government only. I mean, they should have been acting as an independent commissions for the specific purpose of these communities, but as such they are extended arm of government. And after getting independence, they need to act effectively. Okay, like there has to be appointment by an impartial committee, expenditures should be charged on CFI, there should be security. As of now, nothing is there. There is no removal procedure mentioned in the constitution that how are these members going to be changed or removed. So usually when the government changes, these commissions are always reconstituted. So as such they remain in office till they enjoy the pleasure of the president. It's like governor. Then they should be given the power to punish and award compensation, and there should be time bound submission of report and action taken report on their report. Okay, a lot many reports are there, huh? Submission of their report, and then the action should be taken within a time bound manner, and the government should present the action taken report also within a limited time frame. It should not happen that the suggestion has been gathering dust in the ministry for years. Okay, so that's all that we have to cover about the three commissions. Now we are going to take up the next topic, that is about OBC list. This is also which was in news. There had been a lot of center state friction in the last year. I was expecting a question this year, but the question did not come. But this is an evergreen topic. This debate is going to be there, and next year also the question can be asked. So Article 342A mentions that President shall notify a central list of backward classes. Okay, so it is in line with the provision for scheduled caste and scheduled tribe, that president shall declare the caste which would be considered as scheduled caste and scheduled tribe. Apart from that, once notified, only parliament can add, remove any caste. Like a notification issued shall not be varied by any subsequent notification. The same provision we have for scheduled caste and scheduled tribe also. Because similar provision has been done for OBCs also, except one change. The last item, that a state and union territory can maintain their separate list. One more thing that has been done here is, the first is, it has been said that these OBCs or the backward classes, they would be decided state wise. So the list would be prepared by a state. So I'm just giving you an example. So for the list would be something like, in for A, Andhra Pradesh, these are the 10 castes which would be considered as scheduled caste. Then it would be next state, and so on. So if a particular caste is found in more than 2 states, it is a possibility that in one state it may be considered a backward caste, in another state it may not be considered. Okay, maybe the same caste is influential in one state and maybe backward in another state. Okay, so one thing is made very clear in constitution itself. The constitution itself says, if you go and read article 342A, it says the president shall notify the central list and the list would be prepared a state wise. But the same list would not be used by the state government. A state government have been given freedom to maintain their separate list, and it can be different from central list. So it may happen that a particular caste is OBC for the state government but may not be OBC for the central government, or other way around. It may be OBC for central government but may not be ABC for state government. Okay, although the later cases are very rare, it is the former that is more frequent. It happens that there are a lot many castes which are considered OBC for government jobs. So a lot of you might have experienced that you might be getting reservation, the benefit of reservation in your state government jobs, but you may not be getting the benefit of reservation in central government job. The reason is here. And you know, the originally when 102nd amendment, like this article was added through 102nd Constitution Amendment Act. When this 102nd Constitution Amendment was done, this provision was not there. Only these two provisions were there. And the Supreme Court interpreted this provision that only Parliament has the power to amend it. So states do not have the power to notify a separate list of OBCs. Okay, the Supreme Court interpreted this provision that after 102nd Constitution Amendment, the states have lost the power to have a separate list of OBCs for their purposes. So that's why through 105th Constitution Amendment Act, this provision was added that state and UT can maintain their separate list. Okay, I will just sum it up once. 102nd Amendment Act added this article 342A, which said that president shall notify the central list, which would be a state wise, and this list can only be amended through parliament. Okay, the Supreme Court interpreted that this means that a state legislature or state government does not have power to maintain their own separate OBC list. Okay, so then 105th Constitution Amendment gave this power to the state and UT to maintain their separate list, and it was also written that this list could be different from the central list. This is another example that you can use for stating cooperative federalism. See, this is a constitution amendment done by the parliament. Parliament did a constitution amendment to give more power to a state government. This is also something that is strengthening the federal principle. strengthening the federalism. Clear? Then why was it news so much? Because of these kind of things. Okay, like NCBC objects to Bengal demand to include 83 castes in OBC list. See, in one go, Bengal government wanted to include 83 new castes to OBC list. NCBC said that no, this is something objectionable, and this is also considered objectionable because of a religious angle. Majority of this, or rather around 70 of this, yeah, including 73 from Muslim community. Okay, so out of the 83 castes which were recommended, 73 were Muslim community. So simply, like NCBC objected that probably this does not represent the demographic reality of the Bengal. So like if Muslims population is around, say, I'm not exactly aware of the share of Muslim population, but say suppose it is like 25% of the population of West Bengal is Muslims. So among the BCs also it should be around 25%, not exactly, maybe 30% it can be. Not like 90% cannot be there. So that's the objection which was raised by NCBC. NCBC asked for the data, that how did you find that these 83 castes are backward caste. It asked for the objective data which Bengal government failed to provide, or obviously politics start happening after that. Okay. It is also being said that West Bengal failed to provide latest statistic for backwardness mapping. Okay, the accusation is that Rohingyas and Bangladeshi immigrant, they have this OBC certificate and reservation benefits. Okay. Now, next thing that you need to understand is, earlier I have told you that Article 338B mentions that NCBC has no role to play in a state government declaring the OBC list. I have told you that an exemption, like all majority, all important policy matters, a state government and union government must consult NCBC. But there, one exemption was given to a state government declaring the list of OBCs. So why is NCBC now objecting to Bengal government if it has been explicitly exempted? And the reason is that Bengal government wants them to be included in central OBC list. In their state OBC list, they have already included them. All these 83 castes are considered as OBC for the purposes of government job, or uh, say educational institution admission, or wherever it is applicable in West Bengal. Now West Bengal government wanted them to be included in central OBC list. There the role of NCBC comes. So now we will see what is the role of NCBC in OBC list updation. In case of OBC list, what is the role? What is the process? We shall see the complete process. So see the role, this process of adding any caste, because see, the deletion of any caste from OBC list does not happen. As I have told you earlier, once backward, always backward. So if a caste has to be added, the process starts with a state government. A state government sends the recommendation, and the recommendation goes to National Commission for Backward Classes. This commission then constitutes a bench to examine the proposal. It gives it examines the proposal in detail. Then if it agrees, it sends the proposal to cabinet. So here only the Bengal proposal is stuck. In case of NCBC, NCBC asked the statistic from the Bengal government. Bengal government could not provide the statistic, so it simply rejected it. Okay. Next matter goes to cabinet. Then cabinet will send to parliament, because as per the article 324A, only parliament can amend the list. So parliament will pass a law, and only after a law being passed by parliament, president will then issue a notification that now the list of OBC is updated. Okay, here you can see that NCBC on its own cannot start the process of updation of OBC list. No such mandate has been given. Neither the constitution gives it's the mandate, nor the existing SOP procedure says that. So NCBC cannot update it. Okay, only on the request of a state government, and usually a state government only gives a request for adding a particular caste, not of deleting. So probably this process is not of OBC list updation, rather it is the addition of a caste to OBC list. You do not holistically review, you are not holistically reviewing the OBC list. Okay, only you are looking at the demands of various communities in your respective states. Okay. Next thing is that when NCBC is examining the proposal, what is the criteria that it is looking at? Okay, so again it is looking at the social, educational and economic indicators. It is looking at the social, educational and economic indicators. Here also there is one problem. It is looking at the indicators which were fixed by Mandal Commission. Well, Mandal Commission was set up in 1970s. That old criteria may or may not be relevant after say 4 or 5 decades. This is another problem with NCBC. NCBC should have set up or should have been allowed in the constitution amendment to set up its own updated criteria, and it should have the updated socio-economic caste data to analyze or examine the proposal based on current reality. So first you are using outdated criteria, second you have outdated data. Whatever exercise you are doing may not be a meaningful exercise, or maybe a what is a misdirected exercise. The conclusion that you derive may not be right. Okay. Next is we are simply going to revise one aspect that we have discussed in the beginning of the class. We discussed how constitutionalization will bring about a difference. We have seen the difference between a constitutional body and a non-constitutional body. So very briefly, I am just simply making it a explicit terms that what are going to be the changes in case a constitutional status is given to a non-constitutional body. I have told you all the differences that are there. So again the question is going to be in two terms only, whether imparting constitutionality would improve effectiveness or it would not improve effectiveness. So the argument would be the same, that it would improve effectiveness because there would be permanency to the commissions. It would improve in a stature. A stature will definitely improve. Now it's a constitutional body. Okay. Then it would give greater visibility and legitimacy, like in Lakshmikant we will have separate chapter for the constitutional bodies. Okay. And a report would be submitted to the president, primacy to the issue of, like this was the question which is more often asked for minorities and women commission, because these are the two commissions which are currently non-constitutional in nature. So their issue will get more primacy because their commission has improved in a stature. Okay. But again, this is one more thing, do not write there are certain misconceptions with the students. It is not necessary that their recommendation would become binding. This is not true. They are again a advisory body only. Okay. So, or anything like they will get more autonomy. There is no such thing like they will get more autonomy or they will get more power. No, that's not true. Only thing is they will improve in stature, their visibility would increase, prominence will increase. Okay, or they will get more funding. There is nothing like that. So these are the things that you do not have to write. In fact, these are the things that you would write here. Effectiveness may not increase because in the past we have seen with respect to other commission like National Commission for Backward Classes, merely giving a constitutional status has not changed much. Okay, recommendation would still not be binding on the government. There would not be any security of tenure. Appointment of favorites by the government will continue. So all those lacunas which are there in non-statutory bodies, the same is there with the statutory bodies also. The same will apply. Okay, no power to penalty, compensation or prosecution. Dependence on central government for funding and staffing would continue. So all these things will remain the same. So merely giving a constitutional status may not make them an effective body. So what's the way forward? The way forward is that probably the need is to make effective provisions, and whether these provisions are through constitutional amendment or by amending their statutes. Even if by amending their statutes these provisions are made, it will make it effective. However, if the question is that whether there should be given constitutional status, you give yes. Give them constitutional status, obviously improving their stature is also required. The issue will get more prominence. It will show that probably the parliament or the nation is feeling more accountable to these communities, this section of our societies. But we should move, we should go further, we should make them effective as well. So you have to write those suggestions which we have discussed for the constitutional bodies, that these suggestions should also be given, make them autonomous, make them effective, and all those lacunas which are there, this should be addressed while giving them constitutional status. Okay, so that's all that we are going to cover in today's class. I wish you happy Diwali once again, and those of you who are watching this lecture, uh, you are really a great person. You are very much disciplined, committed to your cause, that even in this moment of festivities, you are not leaving behind anything. You are giving your 100% towards your UPSC preparation. You are surely going to succeed in this exam. All the best. And even though you are watching it recorded form in the later on, probably you are still disciplined because you have watched the lecture. Even though you were enjoying the festivities, you may not have watched it in live, but you are following up on the task that you had started. So all the best for the exam. We shall not be having any class tomorrow because tomorrow is Saturday. Next we shall meet you. We shall meet on next Monday. There are two classes left, one of non-constitutional bodies, another of comparison of Indian constitutional scheme with the other constitutional scheme. So Monday and Tuesday, there are 2 days we shall meet, then we shall move towards the next section, that is going to be economy. The economy classes will start from the following week. Okay, take care, enjoy.